The opinion in the federal appeal in the Karen Reed case came out Thursday afternoon. Unfortunately, I was getting ready for a Jewish holiday, which we celebrated on Friday. Then that went straight into the Sabbath. And now, actually, Sunday, I'm scheduled to leave on a plane in a couple of hours to New Jersey. I'll be in New Jersey for a couple of days. I will be back Tuesday or hopefully early afternoon. So I will not be live streaming the Karen Reed hearing on Tuesday, but I will be hopefully catching up on it Tuesday afternoon. And then hopefully getting out my recap and analysis either Tuesday night or Wednesday morning. So let's talk about this federal opinion. Now, before we do, let's kind of set the stage for where we are up until now. So what happened up until now is we know that they already went through the motion to dismiss on the state court level, then they filed, they had this appeal on the state court level, and now they went to the federal courts. Now it's important to understand the distinction between the state system and the federal system, something I talk about a lot. You have to know which system you are in and what the analysis is going to be under. Is it going to be under the state analysis or a federal analysis? Now, I know that this is a federal issue. It's a double jeopardy issue, which is obviously a federal guarantee, but it still is going to depend on where you are. Okay, so let's remember what the two arguments were. The two arguments in this appeal were the following. Number one, Karen Reed was really acquitted on charges 1 and charges 3, and therefore the trial should only be for charge 2. And the reason that she was acquitted is that the jurors are all coming out now and letting us know that really they were only hung on charge 2. So that essentially should work as an acquittal, even though they did not say it in open court. No big deal. Bring them back. Well, they'll all agree that this was their verdict. Charge 1, charge 3, she should be acquitted, and then double jeopardy will attach, and now you can only try her on charge 2. That's the first argument. The second argument is that the mistrial was inappropriate. Now, with respect to the first argument, like I've said a number of times in a number of videos, it's not an argument that's going to win. It's just a loser of an argument, and therefore I don't spend too much time wasted on it because it's just a loser of an argument. We're not going to bring the jurors back for this case. You only bring jurors back when there's allegations of jury tampering, or if there's perhaps some racial or ethnic bias that was interjected into the jury deliberations. We're not going to just bring the jurors back because they forgot to tell us their verdict when they were deliberating. Okay, it's just not unfortunate. It's unfortunate. It's unfair, and it's just one of the parts of our system which is just not perfect. So that's just the way it is, and we're just not going to bring them back. Okay, so let's move on to talk about the issue here, which is a little bit more meritorious, and that is that the argument that Judge Cannoni declared this mistrial and it was inappropriate. It was improper. She should never have declared the mistrial in the way that she did. And if you can prove that, then double jeopardy will attach as well. Double jeopardy doesn't just attach if there's an absolute acquittal on some of the charges, but if the mistrial was declared and it was declared inappropriately, it was improper, well, then the double jeopardy will also attach. And here's where I just keep scratching my head, because really under that analysis, all 3 charges should then be subject to double jeopardy, not just charges 1 and charges 3. And for some reason, which is just beyond me, Marty Weinberg just limited his request to charge 1 and charge 3. Okay, but nevertheless, let's move on to this analysis under the mistrial. Now, if the mistrial was improper, how do you determine whether the mistrial was improper? And how do you determine whether double jeopardy attaches when a mistrial was declared? Well, there's 3 things that you have to analyze. Number 1, did the defense request a mistrial? If they requested a mistrial, then obviously they cannot then argue that double jeopardy should attach. After all, you requested it. So we gave you into your request, and now you're arguing that they shouldn't be able to try you again. You're the ones that asked for it. So if there is a request for a mistrial, there's no double jeopardy. So was there a request for a mistrial in this case? No. So we can very easily move on from that. So that leaves us with 2 more of the 2 more issues we have to analyze to determine whether the mistrial was appropriate or not. The next one is, did the defense consent? So maybe you did not request it, but maybe the defense consented. How do you consent by not requesting? Very simple. If the judge says, I'm about to declare a mistrial, and then pauses for a minute and a half, and you just sit at the table idly by without objecting, that's consent. That means you heard exactly what the judge is going to do, and you just sat there like a shrinking violet, and you didn't say anything. Well, your job as a lawyer is to say things. Sometimes lawyers just can't shut up. But that's what you're supposed to do. You're supposed to do as a lawyer, get up there and object if you have a problem with something. And if you don't object, that means that you are agreeing, you are consenting. So that's the second prong that we have to analyze this mistrial under. The third prong is that even if you can prove that there was no request, and let's say you objected, Your Honor, I object. I do not want a mistrial. We want this jury and this jury only. Then the judge can move on and still declare a mistrial, and the mistrial will not be considered inappropriate. How is that? If the judge determines that there is manifest necessity. Now, here is where it gets fun, because Up until now, every court agrees with this. State court, federal court, these are the three things that you have to analyze. Request, consent, manifest necessity. That's true across the board, state and federal. But here's where it gets fun, and that is, how does a court determine that there is manifest necessity? Okay. Now, in Massachusetts state court cases, in the Supreme Court of Massachusetts, it's clear. It is absolutely clear that two things have to happen. Number one, that the judge has to give counsel full opportunity to be heard, which means this is not a requirement on counsel. This is not your requirement. Your requirement is to object. So if you're moving on to manifest necessity, more likely or not, you had your opportunity and you objected, or you didn't have an opportunity at all to talk. Okay, so when you move on to manifest necessity, it's the court's requirement to give counsel full opportunity to be heard. Let's keep that in mind, because we're going to see something about that in the opinion. Okay, that's one part. Number two is that the court has to carefully consider other alternatives to a mistrial. And if the court does those two things, and the court still determines that it's, you know what, I gave counsel full opportunity to be heard, I thought about reasonable alternatives, but I still feel that there has to be a mistrial. So then the judge, she can declare a mistrial based on manifest necessity over the defense's objection, and there'll be no double jeopardy. Okay. Now, the reason why this gets a little interesting is that in this case, the judge declared a mistrial and very clearly did not give counsel full opportunity to be heard when she declared the mistrial. And she did not really give any sort of careful consideration to alternatives before declaring the mistrial. Yeah, I know, Tui Rodriguez, okay. But actually, when she was thinking about declaring a mistrial, there's no alternatives given. There's no careful consideration given to other alternatives. So when you're analyzing this under manifest necessity, that's where it gets a little bit interesting. That's where it gets where, hey, maybe she has an argument here. Okay. Now, that's all as it relates to state court. That's how the state courts in Massachusetts determine whether there's manifest necessity. And that's why there's definitely part of our argument here for Karen Reed that wasn't done in this case before the judge declared manifest necessity. Now, what about the fact that they did not object? And this is what I've been saying from the beginning. That is really dispositive, because the case law is clear. It's crystal clear in Massachusetts that if defense does not object, that is consent. And even though they had a limited amount of time to object, but they had enough time. Okay, you don't need a minute and a half for the judge to say, you decide whether you're going to object to this next statement of mine. No, that's part of being a trial lawyer. You have to think on your feet. You have to anticipate. They already had a couple of notes came out. There's already a Tui Rodriguez charge. They knew exactly what's going to happen. They knew this mistrial was coming down the pipes. And if they had any problem with it, then they should have lodged their objection immediately. And if not immediately, then once the jury was dismissed, then they could have said an objection then. So this is clear. Okay, it would have been very easy for the Massachusetts Supreme Judicial Court to find that there was consent in this case. Now, for whatever reason, they did not take my advice, and they decided to analyze this under manifest necessity, which was a mistake. And we went through their analysis, and I explained to you why I felt that their analysis was off. Because once you're analyzing this under manifest necessity, you're going to have some problems. But if you analyze this under the objection standard, which is before you even get to manifest necessity, did counsel object? They didn't. So finished. It can be a paragraph of an order saying, sorry, you just didn't object. And the case law is clear. You got to object. The only times that I found in the cases that they didn't have to object is when literally the mistrial came in the middle of the blue, out of nowhere. The judge just walked in and said, you know what, guys, we're declaring a mistrial. Have a good day. And the judge and the attorneys were just sitting there with their mouths open. So that already, you can't expect an attorney to just jump up and object. He's not ready for this. He's getting ready for cross-examination. He's getting ready for an opening statement or closing argument. So if it comes out of the blue, that's where I found in the courts where if you don't object, that's still not going to be considered consent. Or the only other case that I found that was not considered consent is when the attorney was very, very young, and the judge berated this attorney and screamed at this attorney and said his attorney is ineffective, and that she has to declare a mistrial, or he has to declare a mistrial because this attorney is just so terrible. And it was his first case that he ever tried. So he's just sitting there being screamed at by a judge, and he didn't object to the mistrial. So the courts didn't say that was considered consent either. Okay. But in any other case, especially in the case like here, we have seasoned attorneys. This was not a surprise. Everybody saw this coming. They should have objected. And that's it. That's the end of the analysis. And that's really where it should end. And it would have been very, very simple. But they put in a footnote in the Supreme Judicial Court, put in a footnote that we're not even going to analyze this under the consent, because it's so clear that there was manifest necessity here. And like I said, under Massachusetts state law, if you're going to analyze this under manifest necessity, you're going to have some problems. And it's not going to be so clear cut at all. Okay, now let's move on to the federal system, because now after all, we're in the federal system. So how does it work in federal court? Well, let's start with the actual rule of Federal Rules of Criminal Procedure. Isn't that a great place to start? Interestingly, the order doesn't even talk about this rule, which I think is important to talk about. So let's pull it up. This is what it says right here. This is 26.3. Talks about mistrials. I think that this would be a good place to start. And this is what it says. Before ordering a mistrial, the court must give each defendant and the government an opportunity to comment on the propriety of the order, to state whether that party consents or objects, and to suggest alternatives. So, who is the obligation on? Who is the requirement on? The court, right? Just read the rule. Before ordering a mistrial, the court must give each defendant and the government an opportunity to comment, which is just giving them opportunity to be heard, right? And to state whether you consent and to suggest alternatives. So far, looking very good for Karen Reed. Did the court do that in this case? Did Judge Cannoni give Alan Jackson and Yannetti an opportunity to comment on the propriety of the order of a mistrial? Not the order of a Tui Rodriguez, the order of a mistrial. Did she give them the opportunity? This is what this is about, mistrials. So on the propriety of the order of the mistrial, obviously that's what the rule is talking about. And it says must. Right? So if you just look at this rule, it looks very clear that she had to do this and she didn't. And giving the Tui Rodriguez charge has nothing to do with it, because they were not talking about the mistrial then. Now, something I want to point out is that this was added April 22nd, 1993. Okay, and it was effective December 1st, 1993. Okay, so this was amended. This was added in 1993. Now, let's move on now to United States versus Barrero. Okay, now this is a case that happened 2004. Okay, so this is after the new rules, after this new rule was put into place. And listen to what happened in this case. During deliberations following an 8-day criminal trial, the jury sent 2 notes to the district court indicating it had decided some counts but could not agree on others. In response to the first note, the district court gave a modified Allen charge. Following the second note, the district court convened the parties, listen to what happens, received the jury's verdict acquitting the defendants of the decided counts, and declared a mistrial on the undecided counts. So it received the second note. After the second note, calls the jury in. Tell me if this sounds familiar. Calls the jury in after the second note without talking to counsel. Calls them in. Says, okay, we're going to receive your verdict, which you acquitted them on some of the charges, and the other charges you are undecided, so declared a mistrial on the undecided counts. The district court, however, failed to give the parties an opportunity to comment, object, or suggest alternatives prior to declaring a mistrial as required by Rule 26.3, the rule that I just read for you. So this exact issue, this is almost like the mirror issue of what happened in this case, almost exactly. There was an Allen charge. They came out again, and she didn't consult with counsel, and that's it. So she declared a mistrial, and this judge declared a mistrial in this case. And that was in violation of this rule, which says that you have to give opportunity to the comment. This is a requirement on the court. The court did not do this. This is not a requirement on the parties. Okay, now let's move on. Now listen to how this opinion analyzes this rule, because it really completely changes or modifies the way our understanding of this rule is. Okay, so listen to this. Considered collectively, these cases establish that prior to Rule 26.3, meaning before 1993. Prior to Rule 26.3, the trial courts were strongly advised by appellate courts to provide parties an opportunity to be heard before declaring a mistrial. Although the substantive law prior to Rule 26.3 advised rather than mandated that a trial judge hear from the parties, the trial judge's failure to hear the parties was one factor among several that appellate courts considered in determining whether the trial court exercised sound discretion. Against this context, we find that Rule 26.3 was enacted to codify rather than to change the existing law. So, what was the law prior to Rule 26.3? That it was just a suggestion. It was advice that you should do that. It's a great idea to do this. to give opportunity for counsel to be heard. But is it mandated? No, it was never mandated before Rule 26.3. So therefore, this court has found, if you can believe this, that even though Rule 26.3 says must, it is not mandatory. It's just one factor among several that the appellate courts considered. They are and Rule 26.3 is just to codify what was already in the case law, not change it. Not say that before it was a suggestion, before it was advice, but now we are saying you must do it, even though it says must. Now you see what this court is doing? Unbelievable. But that's the law. Okay, so this is what the law is. The primary effect of Rule 26.3 reveals itself as prophylactic. Rule 26.3 recalls to trial judges the critical importance of consultation with counsel. Although Rule 26.3 now mandates that which was previously strongly advised, the failure to hear from the parties has invariably been a factor to be considered when applying the manifest necessity test. So it's a factor to be considered, meaning it's just because a judge does not do it, this is what this court is saying, doesn't automatically mean that there's no manifest necessity. Consistent with the adoption of Rule 26.3, a trial court's failure to hear from the parties remains as one of several factors to be considered in determining whether the trial court exercised sound discretion consistent with manifest necessity. With the manifest necessity test, the extent to which a Rule 26.3 violation indicates a lack of sound discretion must be considered and resolved based upon the individual and varying circumstances of each case. So yes, it should be considered, but you also have to consider the individual and varying circumstances of each case. It's not just did the judge follow Rule 26.3 as the rule actually says must, and if the judge did not do that, then automatically that's not manifest necessity. That's not the way it works. Even though if you just read that rule, that's what it would seem like. You must do this. And if you don't do it, then that should be considered that the mistrial is inappropriate. No, that's not the way you analyze this. It's so important to look at this case law. As Rule 26.3 mandates that a trial court provide the parties an opportunity to be heard, the failure to comply with that mandate necessarily creates a strong suggestion that a trial judge did not exercise sound discretion. Accordingly, we hold that a violation of Rule 26.3, the failure to give the parties an opportunity to comment, object, or suggest alternatives before declaring a mistrial, is one factor to be considered in determining whether a trial judge exercised sound discretion. So, very important case here, that even though the rules, again, says must, take a look, before doing a mistrial, the court must, it doesn't matter if the court doesn't do it, but there still can be other factors which say that in this case, there was manifest necessity. Okay, so what's going to be considered whether there's manifest necessity or not? Does the federal system use the same analysis that the Massachusetts state courts do, which is full opportunity for counsel to be heard and reasonable alternatives? So from here, it would seem that no, it's not actually required. It's not actually required. Now, if you take a look, there's one more case that we have to go through before coming to the opinion, and that is the case of Renico versus Lett. Renico versus Lett is actually a case that this opinion relies very heavily on. It relies very heavily on this case, which is actually a case that came out of Michigan, my home state. And the Michigan court here absolutely made a very bad mistake. But this opinion, actually, if you want to see a very interesting opinion, read this opinion. Go from beginning to the end, because it's a very interesting issue. It's going to really test your legal analysis skills. But we're not going to get you don't have to get into the weeds in order to get to the point that I'm going to try to make with this opinion. But it's still, if you really want a nice challenge for yourself, read this opinion, because what basically happens, I'm going to ruin it for you a little bit. But what basically happened in this case is that although this is United States Supreme Court, although they decided that the Michigan courts made a mistake, they made an error, but it was not unreasonable. And since it wasn't unreasonable under a specific statute, it's okay. They're not going to reverse because of that. So it was a very, very high standard because of the specific statute that was involved in this case, but we're not going to get involved in the weeds in this case. But if you do want to see it, it's a very interesting case. But look what it says here. Okay, this is the Court of Appeals. So it went back a bunch of different courts, did a bunch of different things, and then it finally got to the United States Supreme Court. And this is what it says here. The Court of Appeals also erred in a second respect. It relied upon its own decision in Fulton versus Moore. So this is the United States Court of Appeals. It's almost the highest court in the land. It's right below the United States Supreme Court. And the United States Court of Appeals, they made a mistake according to the United States Supreme Court. Why? Because it relied upon its own decision in Fulton versus Moore for the proposition that Arizona versus Washington, which is one of the cases that we keep hearing about, which talks about a mistrial, for the proposition that Arizona versus Washington sets forth 3 factors that determine whether a judge has exercised sound discretion in declaring a mistrial. Whether the judge, number 1, heard the opinions of the parties, counsel about the propriety of the mistrial. That's number 1. Sounds like full opportunity to be heard. Number 2, considered the alternatives to a mistrial. And 3, acted deliberately instead of abruptly. It then cites, so this is what the United States Court of Appeals did in this case of Renico versus Law, which is, I think, a 2010 case. So pretty much of a pretty recent case. So in this case, when it went to the United States Court of Appeals, the Court of Appeals said, hey, you got to do these 3 things. If you want to determine whether a judge exercised sound discretion, you got to do these 3 things. Number 1, heard the opinions of the parties, which is very consistent, by the way, with Rule 26.3, that you must do that. So this is what the United States Court of Appeals even found. And number 2, that you have to consider the alternative to a mistrial, and 3, act deliberately instead of abruptly, meaning it wasn't too fast. It then cited Fulton's interpretation of Washington to buttress its conclusion that the Michigan Supreme Court erred in concluding that the trial judge had exercised sound discretion. Now listen to this. The Fulton decision, however, does not constitute clearly established federal law as determined by the Supreme Court. So any failure to apply that decision cannot independently authorize habeas relief under AEDPA. Nor, as the dissent suggests, can Fulton be understood merely to illuminate Washington. Washington nowhere established these 3 factors as a constitutional test that determines whether a trial judge has exercised sound discretion in declaring a mistrial. So, if you followed all that, what this case is cementing in stone is that when it comes to the federal system, we don't care as much about whether you gave counsel full opportunity to be heard and whether the judge considered alternatives. We just don't care that much about it, okay? So this is the very important distinction between Massachusetts state law and federal cases. In the Massachusetts state law, it was clear that these 2 things have to happen. It has to be that you give counsel full opportunity to be heard, and it has to be that the judge considered alternatives. But when it comes to the federal cases say very clear that even though this Rule 26.3 seems to say that the judge must do it, it's just one factor that you should consider. Meaning, if the judge decides that there's enough basis based on this circumstances, based on this the length of deliberations, based on the language of the notes, if the judge can say, you know what, the jury is just hung, they're not going to reach a consensus, then that judge does not even have to consult with counsel, doesn't have to consider alternatives, as long as there's a reasonable explanation for what she's doing. And there is a clear indication by the notes, by the extent of the time of the deliberations. If that's enough, that's all you need in the federal courts. That's all you need in the federal system. Okay? So, again, this appeal is in the federal system now. And they're asking them to analyze the double jeopardy clause with what's necessary for declaring a mistrial. So actually, it would be a better place to be in state court. Now, the state court already rejected the appeal, so they went to the federal courts. But in the federal courts, there's, as you see from all this research, that they're just not going to have any chance at all, because as long as the circumstances are enough to show that the judge acted within her discretion, she does not really need to give counsel opportunity to be heard. She does not really need to consider alternatives. Okay, that's what we're seeing clearly from the case law on this rule. So again, it's very confusing because this rule starts off 26.3 that you must give the defendant. And that's exactly how the United States Court of Appeals also found. They also thought that this rule was a must. And that's why they analyzed Arizona versus Washington, which is one of the big famous cases on this. And they found from Arizona versus Washington that you need to have these 3 things that we went through. Now, actually, if you look through the case of Arizona versus Washington, it doesn't say that so clearly. So exactly where they saw it from that case is not so clear, but there are some comments about it. But the point is that even the United States Court of Appeals, I guess, made a little mistake with this. They also thought that you have to give counsel full opportunity to be heard, and that you have to give time to reasonable alternatives. You have to give careful consideration to alternatives. Okay, so now with that backdrop, now that we understand the law, and definitely the federal case law on this. So now, what should the analysis be when it comes to the Karen Reed case? The Karen Reed case should be counsel, Marty Weinberg. You're arguing that there was no careful consideration to alternatives. You're arguing that there's no full opportunity to be heard. It's not necessary. That's what you should say. It's not necessary. That's exactly what the cases all stand for. You're right. It's one of the considerations, but they don't have to go and figure out and do gymnastics, mental gymnastics of trying to figure out how really Judge Cannone did give consideration to alternatives and give counsel full opportunity to be heard. It doesn't really matter. I mean, they could say it, but like that's not really what's going to really make or break this case. If you're writing this opinion with this backdrop, then what your bottom line should be is maybe she should have given more opportunity to be heard, but guess what? It doesn't really matter anyway. It just doesn't really matter. So let's see what this order actually says. Okay. So actually, before I'm going to go to this part of the order, which I'm going to get in a second, I really want to get to a footnote because you know how much I love footnotes, and this footnote is actually very important. So take a look at this. This is the footnote right here on footnote 9. See that footnote 9? Look what it says here. The trial judge concluded that counsel's lack of objection to the declaration of a mistrial constituted implied consent, which what I've been saying from the beginning. The SJC concluded that it did not need to reach the issue because, in my mind, it started off backwards. It started off analyzing this through manifest necessity instead of going through request, then consent, and then manifest necessity. So it kind of worked backwards. So the SJC said, we don't even need to talk about objection or whether there's consent because, there's just simply, we were able to prove that there's manifest necessity. And then look what it says here. This court likewise concludes it need not do so. And again, I think that this is just completely backwards. It's so much simpler to analyze it going from request to consent. And then if you get past those two, then talk about manifest necessity. Why would you make your job so much harder? Just say very clearly, there's no, and the federal cases are also clear about this, by the way. If you don't object, that means consent. And you don't need 10 minutes to be able to object. If you really want to object, you can object. Whether the jury's there, as soon as the jury gets dismissed and sent back to the room, they're able to do that. But again, this court also, this federal court doesn't want to talk about the fact that there was consent in this because it'll make their job a lot easier. I don't know. Okay. Anyway, so they're not going to talk about that either. But then if you take a look at it, they do talk about it, which is curious to me because it makes me think that maybe they are not really understanding this issue 100%. So let's take a look at this. And now that we understand the law very clearly, it's going to be helpful to actually read this opinion because now we're going to see whether this judge is as well versed in the law as we are. So here we go. The court sees no basis to conclude that the trial judge's decision to declare a mistrial was incorrect or improper. To begin, the relevant inquiry is not confined to the brief interval of time between the receipt of the third note and the trial judge's declaration of a mistrial. By that point, the jury had deliberated for nearly 30 hours. That's exactly what we're talking about, right? It's all about the circumstances of each case and had sent 3 notes to the court indicating that they were deadlocked, the latter two making that point with considerable emphasis. The trial judge had held 2 conferences with counsel to discuss how to respond to the reported deadlock, during both of which counsel for the defendant had argued that the jury was at an impasse. After the second conference, the judge gave the Tui Rodriguez instruction. In short, the decision to declare a mistrial was the product of a multi-day discussion between counsel and the court. Now, it seems to me what this judge is trying to do is, well, there was consultation with counsel. Right, they did have opportunity to be heard because of the first and second note and the discussion about the Tui Rodriguez charge. So there was some sort of discussion between the counsel and the judge. But the problem with that analysis, as I've spoken about before, is that they weren't talking about a mistrial. They were not discussing the mistrial at that point. So you can't say that there was that there was full opportunity for counsel to be heard before the declaration of a mistrial when you're considering a mistrial. That was never happened. But I don't even know why he needs to say this because it's not necessary. Doesn't matter if there was full opportunity to be heard because as we just said from the case law, it's not necessary. That's how the federal courts found. Anyway, continuing. Under the circumstances, the judge cannot be said to have acted precipitately and without adequate time for reflection. Nor did the trial judge fail to... Now that's true. That part's good. That the judge cannot be said to act precipitately and without adequate time for reflection. Right. Because again, if you go look at the entire circumstances, And it's not like a requirement that you have to give full opportunity to be heard. So then you can say, yeah, this was a multi-day deliberation, 30 hours of deliberation, multiple notes. Okay, so the judge is being careful up until that point, and then she decides it's a mistrial. So really what the opinion could have said is that it didn't matter whether she actually consulted with the defense at this point. That's not required in the federal system. Nor did the trial judge fail to provide defense counsel an opportunity to be heard. Now, again, it doesn't really matter if they were given an opportunity to be heard, as we just said. The judge solicited counsel's views after the first and second notes, and as we've explained, it doesn't matter. That really has nothing to do with the issue of if defense was given an opportunity to be heard about the mistrial, right? By the time of the second note, if not earlier, it should have been obvious to all parties that a mistrial was highly likely. As for counsel's opportunity to respond to the third note, it is true that the span of time was relatively brief between the point that the trial judge advised counsel that the jury was at an impasse and the point she declared a mistrial. But it was not so brief that counsel could not have objected or asked to be heard. Now let's stop right there for a minute. Counsel could have objected or asked to be heard. That's true, right? So now what is she saying? She's saying, yeah, you're right, it was really quick after the third note, but counsel still could have objected. Didn't you just tell me before that you're not analyzing this under the consent issue? We just had this footnote later on saying we're not even going to talk about whether there was consent or not. Now, let's not confuse the court giving full opportunity to be heard and the counsel's obligation to object. They're two different things. As I said, this is one of the problems when it comes to manifest necessity. Some people, when you see some of these opinions, they actually start borrowing the objection issue and they inject it into the manifest necessity issue. Manifest necessity is not much to do with counsel's requirement as an attorney to make an objection as it does with the court's obligation to give counsel full opportunity to be heard. So here, there's kind of a mix and match here. This judge is kind of taking from the objection standard and saying, well, there was opportunity for counsel to be heard because they had time to object. It's not a question about whether they had time to object. If you're analyzing this under the consent issue, whether the attorneys consented or not, then you can say, yeah, well, they had opportunity to object and they didn't. But if you're analyzing this under manifest necessity, which means that you're analyzing it under where, and you're talking about the opportunity for counsel to be heard, if you want to analyze it under that, which again, in the federal system, you don't need to, but if you want to do that, well, then the requirement is on the court. It's not a requirement on the attorney to make himself be heard. So again, number one, it goes against what this judge is actually saying in his opinion in a footnote saying we're not going to talk about objection, whether that equals consent. But now he's trying to say, well, you didn't object, so therefore that's also be considered full opportunity to be heard. They're two different analyses. Full opportunity to be heard is a requirement on the court. The court has to give opportunity for counsel to be heard. Okay, continuing. I think I made that point clear. Furthermore, after the trial judge declared a mistrial, there's no obvious reason why counsel could not have immediately asked to be heard at sidebar in order to seek reconsideration of her decision before the jury was formally discharged. Yeah, that's true, right? If you are going to analyze this under objection, if you're going to analyze this under the consent issue. Now look at footnote number 8. You see footnote number 8 here? Let's see what footnote number 8 says, because this is an opinion that's not talking about objections, right? This is an opinion that in footnote number 9 said we're not even going to talk about whether their failure to object is consent. Well, what does this footnote say? In this case, Toribio Lugo, the trial judge ruled that defense counsel had consented to the declaration of a mistrial because she failed to make an objection. Do you understand that? So now, this is the case which talks about the fact that counsel failed to make an objection. That means that they consented to the mistrial. Now, you just told me in footnote 9, the court likewise concludes and need not do so. So, are you analyzing this under whether the counsel objected and therefore there's consent, or are you analyzing this under manifest necessity? I've been telling you from day one, you can't mix these up. It's request. Number 2 is consent. Number 3 is manifest necessity. You don't mix and match. If you find that there's no consent, then you move on to manifest necessity. And you're telling me that we're not talking, footnote 9, it says very clearly, we're not talking about consent in this issue. We're not even going there. We're going to be like the SJC. We're not even going to talk about the consent issue. So if you're talking about just manifest necessity, then why in the world are you quoting this case of Toribio Lugo which talks about the defense counsel had consented to the declaration of a mistrial because she failed to make an objection. That only has to do with consent. That does not have to do with manifest necessity, which, if you're going to say under your analysis that you do need to give counsel full opportunity to be heard, which again, like we've been saying, you don't need to do that in the federal system. But if you're going to play that game, well, then you can't just say, well, you didn't object, and therefore you had opportunity to be heard. That's not the way it works. You're right. That's a good analysis under whether to determine whether the defense consented. But once you're moving on to manifest necessity, then the court has to give full opportunity to be heard. So it doesn't matter whether the defense counsel had opportunity to object. That only works when you're analyzing this under the fact whether that the attorneys have consented or not manifest necessity. So that's why I'm saying again that there's a little bit of I'm not exactly sure what what their understanding from the federal case law is. Continuing, petitioner also contends that the trial judge improperly failed to consider alternatives before declaring a mistrial. Now, what should your answer be to this? If you're writing the opinion and you know that the federal court system does not require you to consider alternatives, what should you say? You don't need to. You don't need to. The federal courts don't require you to do that. And then you cite to Renico versus Lett, and you cite to United States versus Barreros, which explain 26.3, which we just spoke about. You don't have to try to explain how there was alternatives. You don't have to try to squeeze in and try to figure out a way that you're able to say the judge can only did consider alternatives. You don't have to do that in the federal system. All you have to do is say it's not necessary. Maybe she did, but it's not even necessary. Well, let's see what they do. The trial judge did, in fact, consider such alternatives in response to the first and second note, and concluded after the second note to give it to Rodriguez's instruction. Okay, but that's not considering alternatives to a mistrial. You're not thinking about a mistrial at that point. After the third note, which again emphatically indicated that the jury was at a deadlock, Massachusetts law required to discharge a jury unless it consented to continue deliberations. Okay, the judge reasonably determined under the circumstances that the jury would not consent to do so. Nothing more was required as a matter of federal constitutional law before the trial judge could fairly conclude that the jury was genuinely deadlocked and should be discharged. In particular, the trial judge was not required to inquire about a possible partial verdict or pull the jury before discharging it. As the SJC noted, to make further inquiry would create a substantial possibility of coercing a verdict. In summary, the trial judge took appropriate steps before determining that the jury was genuinely deadlocked. The evidence that the jury was at an unresolvable impasse was substantial, and the trial judge, in the exercise of her broad discretion, made a well-grounded decision to declare a mistrial, a decision that is entitled to great deference by this court. Accordingly, because there was manifest necessity for the mistrial, petitioner may be tried again on the same charges without violating her rights under the double jeopardy clause. So that's really, and then they move on to the other issues here in the appeal. Now, as we've said, I think the opinion's a little convoluted. It's mixing up some different concepts which really don't really need to be there. You don't have to try to explain how the judge had considered alternatives. And when you try to go down that road, you end up stuck, because at the time that they were thinking about a mistrial, there was no alternatives that was considered. Yes, there was alternatives before, but they were not considering a mistrial at that point. So you're going to run into some problems with your analysis at that point. So really, what the courts could have very simply done, this court with this opinion could have simply done, is just said, it's not required in the federal law. Under federal law, the judge is not required to do that. The judge just has to look at the circumstances of this case. Yes, it's one factor to consider. As the case law says, you can consider whether she gave opportunity for counsel to be heard. And we find that even though she didn't, it's still okay, because in federal law, you don't need to. That's all. It's very simple. Now, if you want to make it even more simple, you don't even have to get to the whole manifest necessity issue, which is my first problem with all these opinions. Just analyze it very simply. Under the failing to object means you consented. Just analyze it like that. It's very simple. You just say that very quickly. The case law is like solid in the favor of the Commonwealth in this case. That if you don't object, that's consent. And then after that, you move on. If you want to be fun, you want to have some fun. So then you analyze it under manifest necessity. So anyway, the bottom line is what I keep saying from this is that the appeal is going to go nowhere. She's not going to win this appeal, but I just keep finding this analysis, and it just seems like the analysis is just off. The SJC's analysis was off, and now this analysis is off. For some reason, everybody loves to talk about manifest necessity, and then they mix and match between the objection standard, the consent standard, and the manifest necessity standard. You got to keep your ducks in a row here. You got to keep things straight. Keep things straight. followed by the counsel, then everything's going to be clear. Anyway, so that is going to be the analysis on this opinion. Ultimately, it was the right conclusion, but again, there's something off with the analysis. So I see that Marty Weinberg already filed another appeal. It's going to go to the next level, the United States Court of Appeals now. And again, it's going to go nowhere, but we'll make for some more content. So I guess we'll talk about it. But that's going to be it for now. Hopefully, have a safe trip, and I'll be back here, God willing, Tuesday afternoon to talk about the Karen Read hearing on Tuesday. So we'll see you all then, and take care. Until then, stay safe.